hearing for mediation for the Nation Drive 2.0, item 1 to 4. Second appeal, 80 of 2080.
The case is otherwise ready for you. Post for final disposal on 10th of March. Since the council for the parties are absent, get a soft copy of this order to communicate.
Item 125, second appeal 169 of 2022.
What is the substantial question of law three? Notice क्या चीज़ है? Notice हुआ था लेकिन substantial question of law बिना बने notice हुआ है. The notice has been issued without clearance. Lesson number 169 of 2022. Also for the appellant submits that the matter may not be sent for mediation. There was an additional evidence at first appellate court, which has not been considered. So we don't have an option. We have to remind it to the court concerned. मीडिएशन में तो नहीं भेजेंगे, करिएगा कब इसकी बात करें? 2004 का सूट है ना? एडिशनल एविडेंस एपेलेट कोर्ट नहीं कंसिडर किया. अब यहाँ पे क्या 20 साल बाद डिसाइड होगा ये चीज? इसको डिसाइड करने में कितना टाइम लगेगा? We'll do it in March with the consent of the learned counsel for the parties. The counsel for the appealant submits that the matter may not be sent for mediation. With the consent of the parties, the matter is posted for final disposal on 10th of March.
Appearance is there. Item 126, second appeal 41 of 2024.
No objection. It cannot be done. What is the substantial question of law?
But all the substantial question has not yet been framed, my lord. But the ground which they have raised is that the London Trial Court's order, which has been affirmed in the appeal, is perverse on the ground that despite them not being present before the London Trial Court and before the London Trial Court, the order has been passed. It is
They are the plaintiffs.
They were the respondents there.
Before the trial court.
For the trial court, they were the respondents. We were the plaintiffs.
So it was ex parte.
Yes, my lord. Although our paper publication and everything was done, but despite that, they didn't appear before the trial court.
One SLP was filed. One SLP was filed in this case. What happened to that SLP? Status of it. SLP diary number 39201 of 20.
Affirm on that.
That has been affirmed.
I'll just confirm that.
You are not well versed. On the last occasion, somebody had submitted on your side only. That SLP has been filed.
Yes,
What happened to that SLP?
No, that is still pending, my lord. That SLP has been filed because the London Coordinate Bench had allowed the limitation application despite there being a substantial delay.
But there is a SLP diary number 39201 of 25 का क्या status? Disposal हो गया ना? कैसे बोल रहे हैं pending?
I was under instruction.
कितना? What instructions?
Board order.
What instructions? Order निकालो इसका. टाइम नहीं मिलता है ना चेंबर में करने. यहाँ पे कुछ भी बोल के नहीं निकल सकते हैं आप. Okay? This is not a court of that nature. जो आप बोलिएगा हम तुरंत वेरीफाई करेंगे.
ये स्टेटस है.
Matter dismissed. Delay control, matter dismissed. ऑर्डर निकालिए भाई, साहब को दिखाइए ऑर्डर. नहीं आप साहब है, आपको दिखाना जरूरी है. मैटर इज पेंडिंग. इसका डिस्पोजल दिखा रहा है 8/9/25 का. The case has not yet been admitted. Vote this case tomorrow.
The advocate, Anish, leadership is the advocate on record. I'm just saying it was posted after some personal difficulties.
Post on 10th of March under appropriate heading.
Item 127, second appeal
ये
45.
स्टेटस लगा दीजिएगा फाइल में, तो दूसरा कोड में फिर यही कहानी सुनिए. Yes.
Item 127, second appeal 45 of 2024.
Yes. This is for mediation.
Marriage is not, state is the only party in this case.
So,
And whether and any land was acquired for the elected period, if the state is ready to pay, then only we will
ready to pay means
that land was acquired without paying a single penny.
okay.
And this is the reversal. Is not
Are you interested in mediation or you are not interested?
only marriage subject to the payment. If they are ready
Mediation में ना decide होगा payment होगा कि नहीं होगा. Yes. Yes, yeah, no. You have to say something. If you are interested in mediation or you are not interested in mediation. The appellant is not ready for mediation. Was this case under appropriate heading on 10th of March?
Item 128, second appeal 47 of 2024.
With the consent of the learned counsel for the parties, the matter is referred for mediation. The parties are ready. When will you appear?
immediately fixed.
The
After 2 weeks, look immediately.
The parties shall appear before the Secretary Khalsa on February 23rd at 11. Let this order be communicated to the Secretary Khalsa so that appropriate mediator be appointed. Post this case immediately upon receipt of the mediation.
Okay.
From the daily court list and ready for final disposal. Fixed case item 4, second appeal 261 of 2017.
There's a title suit arising out of a title suit. I was the defendant. And there's a concurrent finding remaining. There are two substantial questions of law that has been framed. Quite varied,
Yes.
quite order dated 30/11/2019. The first one is whether the appellate court judgment is purpose for considering the exhibit 4 and 4/1, which is registered in the name of Taki Yadav, who is the ancestor of plaintiff, and at the same time not considering the exhibit A filed by the defendant, which is the certified copy of the registered proof showing the name of Balu Yadav, who is the appellant in the second appeal, and thus, in the view of the matter, the judgment of the appellate court below is perverse or not. This is the first one. The second one is framed by order dated 18/8/12/2025. Whether the learned first appellate court, by recording that claim of the plaintiff is in connection with the registered sale deed, was only to the extent of 0.93 acres in Khata number 2, has committed perversity, particularly on account of non-production of sale deed to 46 decimals of land as claimed in the plaintiff. The case of the plaintiff, the scheduled property is 34 decimals.
Just a moment. There are two plots,
There, the suit property.
51 and 229.
But the Schedule B is the suit property validation, that is 34 decimals. In plot number 229.
Suit properties,
Schedule B.
Schedule B, plot number
Plot number is
229.
229.
Khata number?
Khata number 1.
How are we concerned with khata number 2?
I will explain.
This is also a part of Schedule A plot.
Yes. There are two plots in Schedule A validation. Plot number 51 and plot number 229. Plot number 51 is 73 decimals and plot number 229 is 34 decimals. Which we are claiming that it was settled through an oral settlement in favor of Takiya, their ancestor, the ancestor of the plaintiff. Why I am considering this, why I am stating this here, khata number 1 and 2, why we have mentioned this? Because may I give a brief background of the case? That there are two khatas in relation. Khata number 1, which is 1.07 acres, which consists the scheduled property, 34 decimals.
Total area is
1.07 acres. This is khata number 1. It includes the scheduled property, that is 34 decimal in plot number 229. Khata number 2 is 1.39 acres in total. It is through sale deed, which was executed in favor of Takiya, their ancestor, the grandfather of the plaintiff. Now they say that in this 1.39 acres,
grandfather,
I beg your pardon,
grandfather of plaintiffs.
plaintiff, Takiya.
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 Yes.
Now in 1.39 acres, they say that ultimately 93 decimals of land were allotted to them, means the Takiya, 93 decimals, and rest 46 decimals was transferred to a third person by the vendor. So total area is 1.39 acres, and according to them, they were given possession of 93 decimals.
In khata number 2.
Khata number. Validation of all the documents which has been produced by the plaintiffs in support of their stand for possession consist only 2 acres of land. Means the zamindari receipts, the malguzari receipts that they have produced. My case is the defendant is claiming through Hukumnama units, that we are claiming through Hukumnama that was executed in 1941 pertaining to this 34 decimals of land.
You are not able to give the background.
I'll just explain. The case of the plaintiff is that evaluation.
I think we had recorded certain
Yeah, we have.
basic from
The case of the plaintiff is
basic from that. That was rightly recorded.
it was right. Just a moment. Date 12/2025.
Yes.
May I read from para 4?
Yes, you can read from para 6 rather, or para 5.
He submits that the suit property plot number 229, area 54 decimals, as described in Schedule B, and Schedule B is a part of Schedule A property. He further submits that as per the specific case of the plaintiff, the Schedule A property having total area of 1.07 acres was settled by oral settlement in favor of predecessor in interest of the plaintiff. As per the plaintiff, Teko Yadav was the grandfather of the plaintiff, who had purchased 1.39 acres of land of Khata number 2 by way of registered sale deed number 2173 dated 10/5/1944. It is further case of the plaintiff that his father came in possession of the purchased property soon after purchase. At the same time, it has been asserted that it came to light that the vendor had only 10 decimals of land in plot number 130 instead of 56 decimals. Although 46 decimal of plot number 113 Khata number 2 was part of the registered sale deed.
I am not able to get this. Only 10 decimal of land was there in plot number 113 instead of 56 decimal was sale. Although 46 decimal of the plot number 113 Khata number 2 was part of registered sale deed.
So there it
This
has-
registered sale deed consisted of which plots?
Yeah, this is
This
Khata.
is exhibited.
This sale is exhibited. This is Khata number 2, Your Ladyship. The total area was 1.39 acres. The total area.
Total area consisting of how many plots?
Bit 1, that is the registered sale deed. Now there are 4 plots altogether. Plot number 130,
4 plots.
4 plots.
130.
One that consisted of 1.14 acres of land. Out of which 56 decimals was
No. First give me the plot numbers. Plot number 130,
plot number 173,
175,
plot number 185,
185,
plot number 20,
205,
05.
and fourth one
4 plots 130, 175,
and 130.
185.
Okay, we are concerned with 130 only.
No, 229. That is
That is altogether
In
a different
this,
khata.
in this particular deed of 1944, it consisted of which plot numbers?
130, 175, 185, 205. This is not in the schedule of the claim.
Please confirm. This deed, this is the basic document,
yes.
deed dated 10/5/1944.
Yes.
Did it consist of plot number 175, 185, 205 and 100? And none of these properties are part of schedule.
This is not the part of the scheduled property.
This is this deed dated 10/5/44 has nothing to do with the schedule property.
No, it has to.
So far as plot number is
Plot number
concerned,
229.
it is not the same. This is all in khata number.
Khata number 2. Khata number 2, Your Ladyship, is through sale deed. And Khata number 1 is through oral settlement.
We just one by one. So, is it correct that under plot number 130, the total area was 1.14 acres? How much was it sold by this deed?
56 decimals was.
How do you get 1.14 acre? It is mentioned in the
It
deed.
is mentioned in the exhibit. So it is as per the Hindi translation, it is incorrect.
And out of that, the vendor only had 10 decimals of land. This is their case.
This is
your case. That the vendor only had 10 decimals
Yes.
of land, but it was mentioned that there is 56 decimals. Is that correct?
Yes. So total, Your Ladyship, total they are claiming through sale deed in Khata number 2. That is not part of the scheduled property. Is 93 decimals. 93 decimals. And they say that 46 decimals was not allotted to them. It was
Just a moment. Out of in this sale deed, what is the total area?
It's 1.39 acres.
Total area sale is 1.39,
acres.
out of which 46 was not available.
Not
So it is 93 decibel.
93.
So according to them, they acquired 93 decibel of land arising out of the sale deed dated 10/5/1994, although it was for 1.39 acres.
1.39 acres. In Khata number. May I read the
Yes.
para 6? As per the plaintiff, Teku Mato was the grandfather of the plaintiff, who had purchased 1.39 acres of land of Khata number 2 by way of registered sale deed number 2173 dated 10/5/1944. This is the sale deed. It is further case of the plaintiff that his grandfather came in possession of the purchased property soon after purchase. At the same time, it has been asserted that it came to light that the vendor had only 10 decimals of land in plot number 130 instead of 56 decimals. Although 46 decimals of plot number 130 in Khata number 2 was part of the registered sale. It has also been asserted in the plaint that the vendor of the grandfather of the plaintiff had earlier sold 46 decibel of plot number 130 to one Raghubir Mahto, and consequently out of 1.39 acres of land, the grandfather of the plaintiff came in possession of only 93 decimals of land, although the registered sale deed was for 1.39 acres. It has been further asserted that consequently the mutation in the office of landlord pursuant to the registered sale deed was confirmed only to 93 decimals of land. With respect to Khata number 1, the case of the plaintiff is that his grandfather acquired some land from Khata number 1 by virtue of oral settlement from the then landlord, and it included property in plot numbers 51 and 229. The area of settled land was 1.07 acres, 73 decimal in plot number 51 and 34 decimal in plot number 229. The settled land is described in Schedule A of the plan. It has been asserted that the annual rent of aforesaid settled land, 1.07 acres, and purchased land, 93 decimals of land out of purchased area of 1.39 acres, that is total area of 2 acres, was fixed at Rs3. The Schedule B property consists of 34 decimal of plot number 229, which, as per the plan, formed a part of settled land falling in Khata number 1. Further case of the plaintiff is that Teko Mahto died leaving behind his two sons, namely Tokan Yadav and Khemchand Yadav, who came in possession of Schedule A property. However, after the death of Teko Mahto, Tokan Yadav and Khemchand Yadav disrupted their mess and also partitioned the suit land in Schedule A and allotted their respective shares. In the partition, the land in Schedule B was allotted to share of Tokan Yadav, who amalgamated some area of plot number 229 with his Rayati land under plot number 225, which was adjacent to plot number 229. After vesting of Zamindari, the revenue register of the village was prepared in the name of Teko Mahto with respect to only 2 acres of land. The plaintiff claimed that the rent with respect to Schedule B and other land was being regularly paid in the state of Bihar. Tokan Yadav died in the year 1988, leaving behind his 3 sons, and they came in possession of land including Schedule B property.
Just a minute. Teko Mahto and Tokan Yadav are one and the same person. Interchangeably, it is Teko and Tokan are one same.
Teko Yadav is the common ancestor.
Common ancestor.
Toki Yadav is the common ancestor using tradition, and Tokan Yadav is his son. And this the plaintiff is the grandson of Toki Yadav.
Yes.
It It was asserted that the sons of Tokan Yadav constituted a joint family in which Dhalo Yadav, being the elder brother, was the Karta of the family. The plaintiff had also erected a brick compound over a portion of Schedule B property and has remained in continuous cultivating possession over Schedule B property for 12 years.
Now you come to para 11.
The defendant filed a written statement and he claimed only 32 decimals of plot number 229. The defendant claimed that father of the defendant, namely Heklal Mattu, was coming in actual physical possession and as such the ex-landlord in the year 1941 out of area of 1.50 acres made settlement of 0.40 acre of land in favor of the defendant in plot number 51 with a definite boundary and with detailed and described identity. Similarly, the ex-landlord, namely Masori Singh, made settlement of 0.32 acres of land out of 0.34 acres in plot number 229 in the name of defendant by way of Sada Hukumnama in the year 1941. Thus, the defendant claimed to have acquired 0.72 acre of land of Khata number 1 of village Munro, Thana number 82, Thana Bagodar. The defendant claimed 0.40 acre of land in plot 51.
72 is this 72 is addition of 32 and
32 plus 40.
plus 40.
32 decimals in plot number 229
And
and
40.
40 decimal in plot number
51. Oh, 32 plus 51.
Total 72 decimals.
32 plus 40.
32 plus 40.
Yes.
The defendant also claimed that the father of the defendant bought the land measured with the help of Amin, and accordingly, further report of Amin was prepared on 14/14/1942, and the answering defendant had become tenant of ex-landlord and paid rent after vesting consequently. Consequently, he became the recorded tenant of the estate and had been paying rent regularly, which has also been duly recorded in registered book of the state. It was also asserted that the defendant came in actual physical possession of the entire 0.72 acres, including 0.32 acres, which formed a part of the Schedule B property. It was also asserted that 0.02 acres of land in plot number 229 was in actual physical possession of one Lato Yadav, a co-sharer of the defendant. Thus, the defendant disputed the title and possession of the property with respect to 0.3 acre of land in plot number 229 out of 0.34 acre of plot number 229 of Schedule B of the plaintiff. The learned counsel for the appellant had submitted that it is not in dispute that the registered sale deed of the year 1944 in favor of grandfather of the plaintiff was for 1.39 acres, but the learned first appellate court has confirmed the sale deed only to 0.93 acres and has included the area of Khata number 1 to make up total area of 2 acres as claimed by the plaintiff. He has submitted that in absence of any registered sale deed in favor of Raghubir Mattu, the leadership this Raghubir Mattu is the third person who claims that 46 decimals of land was transferred to him. Raghubir Mattu, as claimed by the plaintiff in their plaint itself, stating that 46 decimal of land was transferred in his name. The area covered by the registered sale deed of the year 1944 could not have been reduced and confined only to 93 decimals. He submits that the learned first appellate court has committed perversity by recording such findings. The learned counsel has submitted that the registered document has a presumption of correctness.
That's right. Okay. Now, the first substantial question of law is regarding Exhibit 4 and 4/1 and Exhibit 8. You are the defendant.
I am the defendant.
You are claiming the property on the basis of your hukumnama. At what age were you when this hukumnama was executed?
Approximately 10 years.
Permissible income?
It is not irradiation,
But that finding is staring at you.
it is.
So your entire claim based on hukumnama has been disbelieved by the court.
Absolutely.
Right?
Absolutely.
So that finding is there, which is not the subject matter of substantial question. So your claim on the basis of Hukumnama completely goes. How does your Exhibit A has any role? And Exhibit A and Exhibit 4 and 4 by 1, are they conflicting to each other? They are.
It's the registered to of the plaintiff and of the defendant.
And of the same
Pertaining
property.
Pertaining to same property.
Same property.
Pertaining to same.
Correct. And there are two different, absolutely conflicting. This Exhibit 4 and 4 by 1, which has been exhibited by the plaintiff, is in direct conflict with Exhibit A. Can these two coexist? So the entry in record of rights will not create any title. Entry in register 2 is nothing.
But your ladyship.
Your entire claim is based on a hukumnama, which has been disbelieved by the court. So what right now survives so far as you are concerned?
Now your ladyship, about the defendant also. The plaintiff filed a suit for declaration of plaintiff. Now there may be latches on our part, on the part of the defendant.
You see, at the instance of defendant, this substantial question of law is. Now the point is, what bearing does it have? Does it really have a bearing in the case? This is what I am concerned. As long as the hukumnama stands rejected, what benefit can you draw out of exhibit A? This is my specific question to you.
May I explain?
Yes.
Your ladyship, they say that 2 acres of land were.
And you answer my question first, because my mind is stuck to that question. Even if I decide this question of law in your favor, what will I decide? I will decide that Exhibit 4 and Exhibit A are conflicting to each other. At best, I can decide this, that Exhibit 4 and Exhibit A, they cannot be reconciled. What is the consequence? Consequences we have to see whether the plaintiff has proved his title or not. And at the same time, you also have to see as to whether your claim based on Sada Hukumnama is correct or not. We'll see both the sides, no? Because both of them are claiming title. But your claim on the basis of Hukumnama stands rejected.
Ladyship, their entire claim, if I may permit, their entire claim of 2 acres of land in India. Now, the subsequent receipts, your ladyship, zamindari receipts and the other receipts which has been produced by the plaintiff, Malguzari receipt, shows 2 acres of land. Now, being the plaintiff, your ladyship, they have to stand on their own legs. The owners may only be discharged if they satisfy the court that yes, they have the title. Here is the case, your ladyship, both the courts below have made observations regarding my evidence and this 46 decimals of land, which is very crucial for the reason that all the Malguzari receipt and every receipt mentions only 2 acres of land, and they are claiming 34 decimals of land in Schedule B property. So therefore, your ladyship, some observation, something has to begin in regard of 46 decimals of land, which they say that it was transferred to some other person.
So this sale deed of 1944, if you say that it is taken into consideration in entirety, it should be taken into consideration in entirety, unless there is some material to show that there is a reasonable cause for any deduction. So far as their land receipts are concerned, it does not bifurcate 93 and 1.07.
No, it does not.
None of the
Khata
documents.
number 1 and 2, it is mentioned, and 2 acres of land.
Khata number 1 and 2.
1 and 2 and 2 acres.
And 2 acres of land. Okay. So as far as Khata number 1 is concerned, Khata number 2 is concerned, the entire area would be 1.39.
1.39.
Without any deduction.
Without any deduction.
Okay. 1.39. And so far as Khata number 2 is concerned,
Khata number 1 is 1.7 acres. that is through oral settlement. Khata number 2, without deduction, it is 1.39 acres.
1.39. And if we deduct it from 2, then how much does it remain?
Here is the case relation.
46 decimals.
46 decimals.
Yes, 46.
Yes.
If we deduct it from 2, it will be 46 decimals. No.
Comes to around 2.46 decimals.
2.46
No.
acres in
2
total.
acres minus 1.39 is how much?
That is 61.
60. So 1.39 in khata number 2, correct? If we take the 1944 deed as correct,
Yes.
and 61 in khata number 1,
60. Yes. Yes, yes, yes.
correct? That would be the calculation. And how much they are claiming in 61 in khata number 1?
34 decimals. In this, which is the part of the schedule.
Yes. How much are they claiming in khata number
Khata number
1?
lot number 229, 34 decimals.
34 plus?
34 plus.
No, you are claiming 2 plots, no? In khata number 1.
Yes.
One is
Yes,
34,
yes.
other is 229.
Lot number 51 is 73 decimals in khata number 1. And plot number 229 is 34 decimals.
So 34 plus 51.
No, 34 plus 73 in khata number 1.
34 plus 73. They are claiming 34 plus 73.
73 through oral settlement. And this 34 decimal relationship is the part of the suit property. Is the suit property.
So you say at best for khata number 1 it could be 61 decimal. If we take your 1944 deed, their 1944 deed as correct.
The entire area minus
Just a
46.
moment. What document do they have with respect to oral settlement of khata number 1?
Only the receipts.
Only?
The receipts, Malguzari receipts and the other receipts.
Zamindari.
Zamindari receipts and Malguzari.
Zamindari receipt is referring to any khata number?
Khata number 1 and 2.
1 and 2 both?
Both, 2 acres.
Those receipts may be seen.
Absolutely.
Like it is Exhibit 3. It should be enough if he is able to tell me also that there is any bifurcation in this. Do you get this? Yes, sir. Do you get this?
Exhibit.
You see, you are deducting some area from 1944B by saying that there was a previous sale of 46 decimal, correct? Now, as long as khata, as long as registered deed is telling, there is no question of any deduction unless you actually prove that there was some deed in connection with khata number with 46 decimal. That deed has not been admitted.
But that has not been accepted.
Right? So you are deducting from the sale deed of 1944 to include 46 decimal in khata number 1. Okay. So therefore there is a substantial question of law that in absence of production of that deed of deduction of sale deed of 44 decimal, was it permissible to make deduction in that? Were you able to prove that actually you were entitled to only
61 decimals.
not 61,
Maybe 10 decimals.
that is 93 decimal.
93.
Okay. So which is that document, which is a clinching evidence on record which will show this bifurcation. You just show me that. You just see exhibit 3, 3 by A, which is the Zamindari rent receipt. Exhibit 3 by A at the back side. Exhibit 3 by A at the backside gives the bifurcation. 229.34 decimal, 51 is 73 decimal, 130 is 0.10. वहां से आपको नहीं मिलेगा, यहाँ से. थ्री बाई ए के बैक साइड में. इसीलिए आपको दे दिया, हम जान रहे नहीं होगा आपके पास. पूरा जमीन का बाइफर्केशन है उसमें. किसका जमीन का कितना एरिया इन्वॉल्व है इन दिस रिसीट. You show it to your senior, please. Maybe he has not seen it. You have a look at this.
This is a rent receipt of the issued by the state
That's right.
and registered to may be है. वो that we cannot shy of. Registered to may be है, but all these are based on zamindari receipt. You know, children first see the zamindari receipt because all these
This is
openings are
zamindari
based
receipt
on
only.
zamindari receipt.
This is zamindari receipt only. 3 by A is zamindari receipt. I do not know. कितना लिख रखा है. पहले जो this is one thing. Now let us see the exhibits on the basis of this a substantial question of law. What do you have to make submission on exhibit 4 and 4 by 1?
First
Yes. What submission do you have to make?
Yes, absolutely. With regard to the same document, the appellate court says relies on their register too and discards our register.
So I
With
just
regard
want
the
to
same
know
document.
what do you have to argue on this?
Yes, that
Is it conflicting?
absolutely he could not have done it.
He would not have done it, then he should have rejected both.
Yes, and what it has done, I'll read. I may be allowed to read the finding.
I've seen it, he has not dealt with exhibit A at all.
What they say.
He has not dealt with exhibit A at all.
Exhibit A.
And at the end of the day, your exhibit A has a genesis in your hukumna,
Yes.
which has been totally disbelieved.
Yes, that was the basis because my connection was that I was orally it was settled. Then my on
That
the basis of
hukumnama
that,
has been rejected.
it has been said that because I was minor, therefore that was the
That has been disbelieved.
Yes.
So if your hukumnama has been disbelieved and there is no substantial question of law on that, what ice it will cut so far as exhibit A is concerned? Even if, you see, it is conflicting, right? So if your hukumnama goes, the very genesis goes, the matter ends.
No. If only a person with a better title could have said that my hukumnama, I was 10 years old, or the state could have challenged that no, at the time of opening of Jama Mandi and collection of rent receipt, collection of rent from me after vesting then the state recognizes me as tenant. It has recognized me. So despite
No,
let us
we are on the title.
let us assume that I have defective title on the date when it was settled. But after vesting, the state recognizes me as a year.
You see, election exhibit 4 and 4 by 1 is also certified copy.
Yes.
Exhibit A is also certified
Yes,
copy.
yes, yes. Both
They are
are.
absolutely contradictory and conflicting to each other.
Yes.
So at best you can argue that none of them can be taken into consideration.
Yes.
Right?
Because
If none of them is taken into consideration, where do you stand?
I stand because the entire case of the plaintiff is that although there was a registered deed of 1.39, their vendor had only 46 decimals of land he had already transferred, and he was left with only 10 decimals of land in plot number 229. And therefore, he had already transferred 46. So, only to meet out this calculation, it was absolutely uh, basis of the entire claim of the plaintiff to have brought that particular deed of registered deed to show that no, because my vendor had already prior to transfer of the property to me, he did not have the right over the entire portion. He only had a right over 10 decimals of land, and therefore that deduction could have been. If that document they themselves say that by registered deed it was transferred, and that document is not being brought into record, then how can I be, let us assume that my case is absolutely without any ground whatsoever. Then also only a person with a better title could have evicted me. And they make out the story, and that is the genesis of the entire dispute. They fail to make out.
There is a direction for eviction.
There is a direction.
Is there any direction for eviction?
The decree is the suit be and the same is decreed on contest in favor of the plaintiff. The title of the plaintiff with respect to Schedule B land of the plaintiff is declared and the possession of the suit land is confirmed.
That's it.
So their possession
They are not
is
evicting
confirmed.
you. They are not evicting you. There is no direction for eviction.
So now what would be the consequence? If their possession is confirmed, then it is being confirmed on the plot number 229, which is the suit plot.
Certainly. It is only on plot number 229 which is the suit
and
plot.
one of the main consideration is obviously the registered to entry. Without that, it would not have been confirmed.
No, they are paying rent in connection with 229 also, and they claim that they have got it by way of oral settlement.
Yes.
Followed by rent receipts.
Yes, but rent receipt does not show all those bifurcations. As your lordship pointed out, it does not show those bifurcations.
One of the rent receipt is showing that bifurcation.
The Jamindari receipt was required to have bifurcated, and then I did not have it. But it did not. And whatever calculation is there, there is no signature on that. It is not a part of the receipt.
See, that receipt has not been disbelieved by any of them.
But they have not taken into account all these facts. And what they say that they have assumed, the appellate court particularly, it assumes that out of 139, the plaintiff has only 93. This has been assumed, and the appellate court is deducting on its own without any discussion whatsoever. And in entire appellate court judgment, the entire emphasis is on my defendant's side. Entire discussion.
You see, khata number 1, they have 61 decimal. Even if we take the entire 1.39 of 44, right? 61 decimal.
61, yes.
Their confirmation is only to the extent of 34 decimal.
So how to bifurcate? Now it is their own case that the settlement was 1.07 acres with regard to khata number 1. How to identify that this is the plot area 34 decimal, which is a portion of the 61 decimals. How to come to this conclusion? Absolutely, the plaintiff has to prove his case.
That's right, but
But 61, their own case is that 1.07 acres was settled to them. And even if
where is your rent receipt?
Huh?
Where is your rent receipt?
my rent receipt is there,
Yes. How much is the area mentioned?
74.
D and D divided.
What is the area mentioned?
70.
72 decimals. 32.
72 decibel.
But this is issued by the government rent receipt, Malgujari.
No, you don't have any previous rent receipt.
Not the earlier one. Only Hukumnama is there. Exhibit E is the Hukumnama and or the main report is Exhibit C and B and B1 is the government rent receipt.
So your rent receipt and your hukumnama completely goes. Does it not go?
Even if it is issued in the year 1999, but if the
No,
state
it goes completely. State might have recognized you, but there is a judicial pronouncement that your hukumnama is of no value. State might have recognized. That is why we are on a dispute of title.
can this finding be at the instance of a person who has not been able to identify properly that this is the area which belongs to him? His entire case is dependent on that deed of where his own case is that 46 decimal was transferred to one Raghuvir Mato. He does not bring it into and to fulfill that. Otherwise, if that document is taken into account, then the total area goes to 2.46 acres, which is over and above the rent receipt which they are producing. Rent receipt is only 2 acres. So it is
on the face of Exhibit 4 and 4 by A, and on the face of the fact that you do not have any title, why should your Exhibit A be not discarded completely?
even if Exhibit A is discarded.
Because you don't have any zamindari rent receipt.
My
Not at all. You don't have any
No, I
zamindari
have
rent
not
receipt.
produced.
Right? Your earliest rent receipt is of the year
1999 2000.
1999-2000. Therefore, in the year 1999-2001, when this particular document is being issued to you, is it preceded by some order?
Obvious entry is there in
No,
register.
entry in register 2 is not sufficient because we have conflicting documents now. And then we have to decide which document will prevail.
But the suit was given in 2000.
Suit is of the year 2000. So your document and your Exhibit A is of no consequence.
Even if that document is not taken into account.
If that document is not taken into account, then what remains is Exhibit 4. Exhibit 4 has all the bifurcation.
Exhibit 4 has bifurcation, but Exhibit 4 is based on the earlier rent receipt. They themselves say that it is based on the Zamindari rent receipt. And that does not have the bifurcation, as your Lordship. That is not a part of the Malgujari receipt, of the receipt,
Mr.
Zamindari
You don't
receipt.
have any claim over the property.
But
Your
how
entire
can-
basis.
How is it not against section 92 of the Evidence Act itself, where there is a registered document, registered instrument of transfer of 139, and they say that their vendor did not have title over 46 decimal, and they do not produce the document.
That we'll ask them. But so far as you are concerned, you stand nowhere. So therefore, the first substantial question of law, that is Exhibit A and Exhibit 4 and 4 by 1. So even if we try to resolve this conflict because they are absolutely conflicting to each other. Your entry sheet is produced for the first time in 1999-2001. There is complete silence prior to that. And Exhibit 4 and 4/1 certainly existed prior to your entry in Register 2. Therefore, for the same property, there cannot be another entry without any order.
So, similar thing would apply to them also. In their case also, there's
Yes,
absolutely there's
so far
no
as
order.
first substantial question of law is concerned,
Yes.
it is to this effect, right? So far as the second substantial question of law is concerned, certainly plaintiff has a duty to prove his case. When they are talking about some deduction with respect to property of 1944, certainly they were supposed to produce that registered certificate. They have not produced.
What they have said in their plaint, that statement may be seen. Because they are, if they are unable to prove that document or that statement of theirs, their entire case falls.
No, entire case doesn't fall like that.
Then I may be allowed to read it. I'll read that relevant portion of the plaint. Only 5 to 6 paragraphs of plaint. That the Toki Mato purchased 1.39 acres of land of Khata number 2 of village Mundaro so and so, and now Giridi from Jagannath Lad, Chandraman Lad, Dipat so and so, by virtue of a registered deed of sale dated 10/5/1944, registered in the office of so and so. That on the very date of purchase, the said Toki Mato came in possession of the said land, purchased land. This is very important. So this may be taken note of. They are coming in possession of the entire 1.39 acres, not of the deducted area of 93 decimal. So what they say that on the very date of purchase, the said Tokimato came in possession of the purchased land. By virtue of the said sale deed, Tokimato purchased 56 decimal out of 1.414 acres of land in plot number 1.30 Khata number 2, along with other land. But soon after it purchased, it came in the light of the vendors had only 10 decimals of land under plot number 130 in their possession to sell. So the purchaser Toki Mato came in possession of only 10 decimals of plot number 130 land instead of 56 decimals, as the vendor had earlier sold 46 decimals of plot number 130 to Raghuvar Mato. Toki Mato came in possession of 93 decimals of land out of 1.39. So this is the paragraph on which I will be putting emphasis.
This property of 130 plot number is not the subject matter of this.
No, it is not.
It is not
It
the
is
subject
not.
matter of this,
So-
right?
So I'll complete it. I get your lordship's point. My only contention is that first statement has to be seen that the deed by which they purchased, it was for 1.39, and they say that immediately on the date of purchase they were in possession, they came in possession of 1.39. So if they produce the rent receipt for 2 acres, so only 61 decimal is remaining. How to identify that this is the 61? This is the exact
Okay.
area which is falling.
Even if the 61 acres cannot be identified, certainly 34 decimal, which is the part of Schedule B property,
Yes,
is certainly less than 61,
less than 61. But
right? And they were found in possession.
Yes, I do get your lordship's point.
And they were found in possession.
Now, what would happen that why it is not beyond 2 acres? Because if their entire
Because
deed
the
is
rent
taken-
receipt is of 2 acres.
I'll come. Now, if their registered deed is taken into consideration and their statement with regard to settlement of land made to them, the total area comes to 2.46 acres of land.
That's right.
And not, so why
See,
this particular,
they have given up the title, they claim for whatsoever reason with respect to 46 decimal. In the suit they have given it up, right? Nobody is disputing their title in plot number 130. They have themselves given it up. Now, so far as 61 decimal in khata number 1 is concerned, at best they can claim 61 decimal in khata number 1,
61.
right?
Yes.
So that is not the dispute.
But
The point is that they are in 34 decimal of land. They are in possession of so far as schedule B property is concerned, it is just 34 decimal.
34, but why it is within that 2 acres, why it is within the 61, how to identify? The court has not, both the
Court
courts
has
have
not
not made that
identified. There will
exercise.
be another round of litigation. What is the big deal about
Both the
it?
courts
They
have
are in possession, right? If you want,
No, their possession, the finding on possession is based only on registered.
no, whatever it is, that is not the substantial question of law. We will not bother about it.
But while answering,
There is a finding so far as their possession is concerned. Now, if anybody who has title over the property, they will sue them for taking possession. But so far as you are concerned, you have no right.
I'll come to
Because
that.
your hukumnama is completely disbelieved by the courts.
Title suit first trial court judgment may be seen what it says, and that has not been discussed by the appellate. It is established law with regard to my register that mutation of name or creation of jamindari neither creates nor in right title interest on land. It merely allows a person to have his name entered in register 2 for the purpose of payment of rent. Therefore, on account of entry of name of dependent in register 2, no title created in his favor. Premised on this principle, preponderance of probability, I find that the case of the plaintiff is more probable and worthy of reliance and better title and the defendants. In this view of the matter, I convincingly find and hold that the plaintiff has subsisting right title interest over the suit property in view of the matter so and so. And then when it comes to their own register 2, it says that at the time of deciding issue number 6, I had already found that oral settlement of agricultural lease is valid. The plaintiff in support of oral settlement has produced jamindari receipt as well as state malguzari receipt. From the jamindari receipt as well as malguzari receipt filed by the defendant, it indicates that he is paying rent for total 2 acres of land, and on that basis his name is recorded in register 2, where separately specific Rakpa of suit land is mentioned. In civil litigation, payment of rent is considered an evidence of possession. The oral evidence regarding oral settlement is in corroboration.
You see, your entry in register 2 is earliest in the year 1999 to 2001. Not that. 99 2001. That is your oldest rent receipt that you have produced.
It is 90. Yes.
Right, that is the oldest one. And you paid the rent when? When did you pay the rent?
To 99.
99. No, 99 or 99 to 2001. You must have paid in 2001. What is the date of the rent receipt?
It is in the year 1999 and 2000. We have executed 2 rent receipts.
Two
From the
different
year
rent
99
receipts.
and 2000.
99 and
2000.
2000 you have not exhibited. 99 is a separate rent receipt, which is exhibit number. B is also issued in 2001. B is issued in 2001, not in 1999. B by 1 is 1999, 17/6/1999.
Yes.
This is the earliest.
This is there.
Then how did you get your name entered in the register 2? when there is already an entry in the register 2 with respect to the same property? There should be an order.
That is not reflected from
That
this.
is not reflected.
No.
So why should we believe your document?
But similarly, their own register 2 also entry also was required to have been.
It was certainly prior in point of time. What is the oldest government rent receipt you have produced? इनका तो vesting के time से.
Earlier, it is earlier.
It is earlier. So your entry in register 2 is of no consequence. And that certified copy, we do not know. Both of you never called for the original register 2. प्राइमरी एविडेंस से एग्जिबिट कराना था ना उसको. अब सर्टिफाइड कॉपी क्यों लेकर आए?
18,157, that is post basin.
यस. जब कॉन्फ्लिक्ट था तो प्राइमरी एविडेंस प्रोड्यूस करवाना था ना.
Bifurcation first time आ रहा है register 2 उससे पहले नहीं.
नहीं, उसके पहले रेंट रिसीट में तो
नहीं उससे पहले जो रेंट रिसीट्स है वो जो जमींदार
जो बाइफर्केशन रजिस्टर 2 में है.
हाँ,
अगर उसमें कोई एंट्री गलत है और आपका नाम एंटर करना है तो कोई प्रोसीडिंग होगा ना कि ऐसे ही एंट्री हो जाए. ऐसे तो नहीं होगा ना. वेयर इज दैट प्रोसीडिंग? You cannot say that your name was entered prior in point of time because you do not have any rent receipt prior to that.
नहीं. It was in 1992.
Then
It was.
it was in only 99-2000. इससे पहले का था है.
Now, लेकिन can that be a basis of the
Because you have both
degree of the
substantial.
entire suit?
First tell us, both of you, is exhibit 4 and 4/1 conflicting with exhibit A or not? You just tell us. If it is conflicting, we have to resolve the conflict. इसीलिए substantial question of law बनाया नहीं तो क्यों बना?
Conflict है इसीलिए दोनों के बारे में हम लिखा है कि दोनों का रिपोर्ट का अलग-अलग फाइंडिंग है.
The entry with regard to the plaintiffs is 34 decimals, and with regard to the defendants is 32 decimals.
Yes. They are only claiming 32 decimal only because they also say that 2 decimal is with somebody else.
And the bifurcation is there in the register.
तो आपको बता ही नहीं bifurcation आपके केस में है, but the point is वो जो 32 decimal उनके में है और आपके में जो 34 decimal है, but there is a conflict between. Is there any conflict or there is no conflict?
There is a
Overlap है ना दोनों में.
32 decimals वो बोल रहे हैं, हम 34 decimals.
34 decimal बोल रहे हैं और this is plot number
229.
229. 229 का total area कितना?
34.
टोटल एरिया 34 है, तो ओवरलैपिंग तो है ही ना, देयर इज ओवरलैपिंग.
But this went, this register 2 entry from the description of the years, it appears to have been in 73, 74, at least prior to this.
No,
register
certainly
two
they also don't dispute that your entry is prior to their entry.
So if at
So
all
that-
there is a change in the subsequent entry, there has to be a proceeding.
क्या बोल रहे हैं, आपकी फेवर में बोल रहे हैं ना, तो वही तो इनसे पूछ रहे हैं, सवाल इनसे इसीलिए पूछ रहे हैं.
मानो नहीं बात करो.
अब ये तो हो गया, अब आप दूसरे वाले केस में क्या?
Last term submission. एक हम और एक भी लाइन है. I assure you. Would you kindly turn to exhibit B3B, 3C and 3D. These are the three Jamindari rent receipt. And Jamindari rent receipt would be the only basis for opening of Jamabandi in their favor after this. These three exhibits may kindly receive. If there is no bifurcation in this, there is no discussion in these documents that it was related to plot number 229. How after vesting this bifurcation to happen? Three, 3B, 3C and 3D.
3A is जमींदारी रेंट रिसीट.
नहीं 3 ये वो सब बाकी स्टेट का है.
तो कौन सा है जमींदारी रेंट रिसीट?
वही बोले 3B, 3C and 3D. पीछे साइड में लिखा हुआ सब.
ठीक है, आपको क्या बोलना?
So far, the identification of the Sultan is concerned. We will continue to refer to the claim. It is properly butted and bounded.
That's right, it is.
And at para 13 of their written statement, they admit that their 72 decimals of land embraces this 34 decimals. If I may be permitted to read that particular line, para 13. It's a longish paragraph. On page 4, we'll find fifth line from the top. This 0.72 acres of land embraces 0.32 acres of land in suit detailed and described in Schedule B and 0.72 acres of Schedule A.
अभी पहुंचे नहीं हैं. Para 13.
Para 13 on the subsequent page. this 0.72 acres of land embraces 0.32 acres of land in the same detail and described in Schedule B, and 0.72 acres of Schedule A of the plain, whereas 0.02 acres of the land in plot number 229 is an actual physical violation of one Latu Yard, a co-share of the answering. So plot is identified. Even assuming 61 decimals, it is identified. They have not rebutted on this point that the boundary is given is wrong.
That is not their case.
They have not. And the case set up by my senior here is never pleaded there, madam, at the original stage. There is no evidence to that effect, madam. And obviously there could not be any issue to that effect. And no finding is to that effect. Secondly, I did not bring it in the suit for any other plots. It is only connected with one plot, 229. My claim, and this would we are not claiming any property which has been acquired by virtue of the registered sale. It is oral settlement followed by zamindari rent receipts, then register 2 entry followed by the regular rent receipts, government rent receipts.
That's right.
So the finding given by the learned appellate court at para 16, which my senior was referring, that on careful scrutiny, scrutinizing the oral evidence and documentary evidence of both the parties, I find that the case of the plaintiffs are more probable and worthy in comparison to the defendant. Plaintiff in support of oral settlement has brought zamindari rent receipts and thereafter malguzari receipts. Register 2 has been filed by the plaintiff. In comparison to the plaintiff, defendant did not bring any zamindari rent receipts. Sada Hukumnama and Amin report do not seems to be genuine paper in view of the discussions. There is a striking off money and there is an overwriting in the further. This is what the learned court is referring here. But this finding is in the contextual, if we see, is in the light of the Ummi Devi's case. That oral settlement followed by zamindari rent receipts, their entry in the government records.
That's it.
Last two judgments are
And
yes.
one judgment I will please for time consideration. So far, my validity, if at all my scrutinizes my validity of the registered sale, but it would still be valid so far my vendor holds the title to that extent. I have one judgment.
But that is still valid. There is no doubt on that. But you have given up the right with respect to 46 decibels.
Absolutely. And I claim only 10 decimals because my vendor had only 10 decimals. And that does not relate to the schedule.
Therefore, there is one more substantial question of law with respect to non-production of the sale deed. Yes.
This is settled principle, but only to complete my argument, para 15-16, that and it would include the relief paid by the plaintiff here. It is strike law that in a suit for declaration of title, the burden always lies on the plaintiff to make out and establish a clear case for granting such a declaration, and weakness, if any, of the case set up by the defendant would not be a ground to grant such relief. So here is a case. Now they have set up, they have made certain calculations in their entire claim, and they are not able to prove a vital fact as to how that 2 acres came. Now,
So we will
as
also
your lordship pointed out, that 61 decibels was there. Now it is not their case.
No, it was your
Third
case.
case cannot be now
No,
made.
it's not being made third case. At least, you see, they say through purchase one portion, through oral settlement another portion, and there was a rent receipt of 2 acres. This aspect is not in dispute, right? They want to reduce the portion of the purchased land to have more area in the oral settled land. Right? even if they are not permitted to reduce it on account of non-production of their document with regard to the 46 decimal. Their claim with 61 decimal is certainly fortified. There is no doubt on that.
It is not the case.
May
which
not
they
be
have
their
made.
case. May
It
not
is a
be their
case which they have made that
No, but
my
you see,
vendor did not
just a
have.
moment. Whenever we see the case of the party, we have to see the plaint and the written statement both.
Yes.
Right? And you claim 32 decimal within this area. It is as pointed out by him in paragraph 13 of the written statement. Your claim was within this area. 32 decimal.
Yes, because total area itself is 34. So
No, 30. You just have a look at this statement. Registered to maintained by state, and thus the answering defendant is coming in actual physical possession of all lands measuring 0.72 acres with all rights and interests, and 0.72 acres of land embraces this 0.32 acres. Paragraph 13.
yes, 72 decimals of land.
Yes.
This 0.72 acres of land embraces so 72 acres of land. I mean my land, which has been settled to me, not the land which has been settled to them. I am referring to the settlement made to me. That, as it was pointed out, I was settled twice, 40 and 32, and total area comes to 72. Therefore, it is being said that these 7.72 acres of land embraces 0.32 acres of land in suit detailed and described influence, whereas 0.2 acres influence. So, this is with regard to my settlement. I am not talking about their settlement. And why I said third case, it is a reason. I'm not saying that is not empowered to make out, to discuss cases, and that is not my submission. I say that because the entire plaint itself, the plaintiffs have made out a case that because my vendor did not have 46 and therefore 1.07 acres was settled to me, and this total comes to 2 acres. This is the calculation which I made. So 1.07 and 93 decimal of their registered sale, not 1.39 and 61 decimal. This is not there. This is not. Not
The fact that the rent was accepted way back in 1956 with a clear bifurcation. Why should that be not accepted?
But it is based on the registered 2 entry is based on the Jamindari rent receipt, which does not show all the information.
This registered 2 entry is not only based on Zamindari rent receipt, it is also based on some returns filed by the Zamindar. There are certain other aspects of the matter. What was the basis of this entry is not on record.
There's no signature in the backside. It would have been at the front itself, where khata number 1 and 2 is being mentioned, that these are the plots for which the rent receipt is being accepted and that is signed. Now, if someone is entering at the backside of the same page, he has to put a signature to that it is a part of the rent receipt. How do we get that it is a part of the rent receipt? These plots for it are being
there is clear entry in register 2 also.
register 2 it is there. Register 2 entry is there.
So
Register
entry made in register 2 way back in 1956.
Can that be only ground for
That
because
is enough.
That is all.
वो ऑर्डर लास्ट ऑर्डर ले लेंगे आपका, उसमें जितना सबमिशन से सब ले
हाँ,
लेंगे,
हाँ, सब-
है ना, उसमें तो
सब-
सबमिशन से
नहीं,
करेक्टली रिकॉर्डेड.
हाँ, correct.
With respect to the first substantial question of law framed by order dated 13th of November 2019, the Learned Counsel for the appellant has submitted that Exhibit 4 and 4/1, which is a certified copy of the Register 2 and produced by the plaintiff, has been taken into consideration, but Exhibit A, which is also the certified copy of Register 2, has not been taken into consideration by the Learned First Appellate Court, and therefore the impugned judgment is perverse. The Learned Counsel has submitted that Exhibit 4 and 4/1 is the entry in favor of Taki Yadav, the ancestor of the plaintiff, and Exhibit A is the entry in the name of the defendant Balo Yadav.
Can I take leave?
Yes. During the course of argument, it transpired that the earliest rent receipt which the defendant had produced in the present case is of the year 1999. The defendant had produced two rent receipts, Exhibit B and BY1. Exhibit B was issued in the year 2001 and Exhibit BY1 was issued on 17/6/1999. Admittedly, the defendant has not produced any rent receipt prior to this meeting,
Prior to 99.
not even zamindari rent receipt. It further transpired that there is a conflict in entry in Exhibit 4 and Exhibit A. In Exhibit A, the entry has been shown in favor of the defendant to the extent of 0.72 acres in Khata number 1, and the bifurcation mentioned is 0.32 acres in plot number 229 and 0.40 acres in Khata number 51. And it was the specific case of the defendant that they had acquired this property by way of hukumnama way back in the year 1941. So far as Exhibit 4 is concerned, the same was produced by the plaintiff, wherein which is in the name of the ancestor of the plaintiff, Teki Mehto, and the bifurcation of the property has been mentioned therein as plot number 130 0.10 acre, 175 0.22 acre, 182 0.16 acre, 204 0.25 acre, 229 0.34 acre और एक बीच में कौन सा बच गया 51 0.73 acres. And the plaintiff has produced rent receipts issued by the zamindar to the extent of 2 acres and also rent receipt issued by the state right from the year 1956. 1957. The learned counsel for the appellant has submitted that the zamindari rent receipt did not give the bifurcation of 2 acres and therefore there was no basis to have the bifurcation in registry. However, it is further not in dispute during course of argument that Exhibit 4, though is in conflict with Exhibit A, but Exhibit 4 is prior in point of time, as the plaintiff has produced rent receipt right from the year 1956 also. The learned counsel submits that had Exhibit the learned counsel submits that Exhibit A has been totally discarded and Exhibit 4 has been believed. Exhibit A has not been discussed by the learned first appellate court and Exhibit 4 has been believed and therefore the impugned judgment calls for interference. The learned counsel appearing on this substantial question. The learned counsel appearing on behalf of the respondent, on the other hand, has opposed the prayer and has submitted that the hukumnama, which was the basis of the claim of the defendant, has been completely rejected by the court by saying that by citing numerous reasons, including the fact that the defendant was just 10 years of age in the year 1941. He has submitted that no substantial question of law has been framed in connection with the finding of rejecting the claim of the defendant on the basis of Hukumnama of year 1941. The learned counsel has also submitted that the Hukumnama was not even followed by any rent receipt, and all of a sudden in the year 1999, for the first time, rent receipt has been issued in favor of the defendant. The learned counsel submits that under such circumstances, the Exhibit 4 admittedly being prior in point of time and also supported by rent receipt, which also gives the details of the bifurcation at the back of Exhibit 3. In such circumstances, 3 by A, 3A, at the back of Exhibit 3A, the Exhibit 4 will prevail he has submitted that neither any circumstances nor any order has been placed on record by the defendant as to how their name has been entered in Register 2. There is no order deleting the name of the plaintiff from Register 2, and therefore any such entry in Exhibit A has to be discarded. With respect to the in response, the learned counsel for the appellant has submitted that merely because at the back of Exhibit 3/8, the details of the property has been mentioned, the same, it is not clear as to how the entry has been made at the backside of the rent receipt. So far as the second substantial question of law framed by the order dated 8/12/2025 is concerned, the learned counsel for the appellant has submitted that the sale deed dated 10/5/1944 within bracket Exhibit 1 was for 1.14 acres of land. 1.39 acres of land, and the plaintiff suo motu claimed that the vendor had only 46 decimal of land, although only 10 decimal of land, although 56 decimal of land was mentioned in the aforesaid sale deed with respect to plot number 130, khata number 2, and has suo motu deducted the claim in khata number 2, plot number 130 from 56 decimal mentioned therein to only 10 decimal. Further, the plaintiff also claimed oral settlement followed by zamindari rent receipt
1.07.
to the extent of 1.07 acres of land
Khata number.
in khata number 1, and the bifurcation is
Lot number 51,
plot number 51,
area 73 decimals,
area 73 decimal, and plot number
229,
229, area 34 decimal. The learned counsel submits that since the zamindari rent receipt was issued to the extent of 2 decimals, the plaintiff, 2 acres, the plaintiff deducted the area from plot number 130 of khata number 2 and tried to adjust it in the aforesaid 2 plots of khata number 1. The learned counsel submits that such deduction was not permissible in the absence of any registered sale deed in connection with 46 decimal of land which the plaintiff claimed to have been transferred to a third party, and the vendor had only 10 decimal of land instead of 56 decimal of land in plot number 130, khata number 2 as mentioned in the sale deed dated 10/5/1944. The learned counsel submits that in absence of the sale deed in connection with 46 decimal of land in plot number 130, khata number 2, the suit property would not have been, the title with respect to the suit property would not have been declared in favor of the plaintiff. During the course of hearing, it transpired that if the entire area of sale deed dated 10/5/1944 is taken into consideration, read with the zamindari rent receipt for 2 acres of land, then also the remaining area with respect to khata number 1, which may be available to the plaintiff, is to the extent of 61 decimal. The plaintiff has claimed title in khata number 2 wide sale deed and further settlement in khata number 1, which was said to be orally settled by the zamindar, followed by zamindari rent receipt. The learned counsel has submitted that the burden was upon the plaintiff to establish his case, and merely because the hukumnama of the defendant was disbelieved, the same will not be a reason to allow the case in place in favor of the plaintiff. The learned counsel for the respondent, on the other hand, has submitted that non-production of sale deed in connection with khata number 2, plot number 130, 46 district, as claimed by the plaintiff to have been actually transferred by the vendor prior to execution of the sale deed dated 10/5/1944, has no bearing in this case, inasmuch as the suit property is relating to khata number 1, and in particular plot number 229, area 34 district. He has referred to the written statement of the defendant, para number 13, to submit that the defendant claimed that the ex-landlord has made settlement of 0.40 acres of land in plot number 51 and 0.32 acres out of 34 decimal of land in plot number 229 in the name of the defendant by virtue of Sada Hukumnama. And has also the learned counsel has further stated that it is not in dispute that total area of plot number 229 was 34 decimal and the defendant was claiming only 0.32 acres in plot number 229 on the basis of Sada Hukumnama. He submits that Sada Hukumnama has been completely disbelieved and therefore the defendant has no role to play. He has further submitted that even the possession with respect to the suit property has been found in favor of the plaintiff and the possession has been confirmed. No substantial question of law has been framed in connection with the said finding recorded by the learned First. The Learned Council has submitted that non-production of the sale deed in connection with 46 decimal of land in plot number 130 does not make the findings recorded by the learned court perverse in any manner. After hearing the learned counsel for the parties on their question to substantial questions of law, this court finds that the plaintiff claimed 12:30 बज गए. I dismiss this appeal. You will have the reasons. Submissions आपका सारा record करें. 12:30 बजे we have that fixed time for you can take the progress. The appeal is dismissed.
Yes.
On the last occasion, I was directed to furnish the bank account details of the respondents.
हाँ.
So we have the phone.
Yeah. Like this. एक चीज और लिखिएगा. The office is directed to remit the cost deposited by the appellant in the following bank account. In the name of Jagdish Yadav, who is Jagdish
He
Yadav?
is respondent number 4. Lift the back.
A detail. The detail furnished is kept on. थोड़ा सा 10-15 मिनट भी रहता ना फिर ऑर्डर 41 वाले मैटर्स टेकअप नहीं होते. इसने काफी काम किया हुआ है. मुकुल, वो पंकज है आप ही का है. मुकुल, इसमें काफी काम हम लोग का किया हुआ है. पंकज जी का ही किया हुआ है. सारा फाइलिंग्स वगैरह सब एक जगह लिखा हुआ है. ट्रायल कोर्ट एप्लीकेशन का सब एक जगह. ठीक है. तो थोड़ा ही सा डिक्टेशन बचा है. 4:30 बजे. इसका सॉफ्ट कॉपी दे देंगे.
From the supplementary
आज
list,
छुट्टी पे थे ना?
आज नहीं कल के लिए डाले थे, कल के लिए डाले
11
तारीख थी.
from the supplementary list under heading for hearing under order 41 rule 11 of CPC item 62, second appeal 383 of 2019.
Yes, please. You are the plaintiff. You are lost in both the courts. What is the substantial question? Page number 31. Yes.
Apart from arguing the case both sides, I have written notes of arguments and state that the argument would have argued.
नहीं 31 आपका नहीं मिल रहा है.
Remember internal case 7 of the appellate court.
Internal case.
7
Okay.
of the appellate.
Yes.
Also, the learned counsel of the appellant plaintiff state that the learned court has heard in deciding the case there is deed of surrender exhibit C and C1 where the Dayal Bawri and minor son of later of a Nayan Bawri, with their guardian Guru Bawri and Raja Singh Sasi, to the extent that 2/3 share is padding. Dayal Bawri and minor sons Nayan Bawri could not do so. If they have surrendered 2/3 shares, they are remain in possession of one share jointly. What is happening, my daughter? Actually, the case is like this. The plaintiff has filed for declaring the entitlement of half of the land in all 16 plots comprising of area 4.47 acres in Khasa number 51, village number. And
The suit for declaration of title.
The recorded name of the tenant is Babu Ram Bawri and Bibi Bawri. Both are the sons of late Benjo Bawri. Each one share each. Narayan Bawri and Dayan Bawri. That is come in para 2 page, the internet page. As recorded in the name of Babu Ram Bawri and Bibi Bawri, both sons of late Benjo Bawri, one share each, and Narayan Bawri and Dayan Bawri, both sons of late Latu Bawri, one share each, during character celebration. Benjo Bawri and Latu Bawri separated themselves.
See, the entire property was already surrendered. So what right do you have?
What share still exists, my lord. This has not been taken into consideration. This is the point which is involved.
No, one
That
share
has
is
come in
not
paragraph
existing.
number 7, it has been raised. This point has been considered. This has not been considered by both the learned courts, my lord. This is the substantial structure which will surrender. When there is joint property, jointness in the property, partition is not there by bits and bonds.
So you are belonging to the same family.
Same family.
No.
Same family.
So Jatan Mandal.
Para to see, I will begin from para to Mandal. New person has been learned.
Where is the genealogical table?
Genealogical table.
Schedule A.
Genealogical table that is Schedule A.
Yes.
Ramya Bawri, Babu Ram.
Schedule A does not find mention of any of the defendants. Schedule A में कहाँ कोई defendant?
Babu Ram sold and transferred to Ramya Bawri. Babu Ram is there. Babu Ram Bawri.
Babu Ram is another person. Babu Ram is not the ancestor of the defendant.
Babu Ram is also ancestor.
Ancestor of the defendant. Ancestor of the defendant. No, he is not the ancestor of the defendant.
But I am just reading this paragraph and put everything will come.
But read it, para 7.
Should I begin para 7 or para 7? I go this after both the cases. Both sides have written notes of argument. The Library Council of the Appeal, state title, Library Lower Court has heard in deciding suit. There is state of surrender exhibit C and C1 made by the Dayal Bawri and minor sons of Nayan Bawri through their guardian Budu Bawri and Raja Shivprasad Singh to the extent of 2/3 share is bad in law. Dayal Bawri and minor son of Nayan Bawri could not do so. If they have surrendered 2/3 share, then they are remaining in possession of one share guardian. Meaning thereby, Dayal Bawri and Nayan Bawri have jointly half share. There is state of surrender illegal non-inquired because portion of the joint property cannot be surrendered unless partition took place by means and bounds. Surrender was done in contravention of the provisions of Minority and Guardianship Act. The Learned Council of the Appellate Relations has discussed Section 8.2.3.5 of Hindu Minority and Guardianship Act. The plaintiff's appellants had no knowledge about the existence of force in fabricated deeds, so they have never challenged the same. No M form or K form, no return of excellent or are brought in report. Without appreciating the evidence, the learned word court has passed the judgment and decree. Thus, no partition by meets and bounds. So, co-sharer cannot surrender the joint property. The plaintiffs are in possession of the sole property. The learned word court has given undue weightage to the surrender deed. The revision survey record of right is not an evidence. The revision survey cannot be treated as document of title. The certified copy of the surrender deeds are held on record. The original surrender certificates, the surrender deed has not been found. The Jamindar must have handed over the original surrender deed to the settler. It was duty of the defendant respondents to prove this fact. The rent seals are not the documents of the title. The learned counsel of the appellant plaintiff has discussed in detail the evidence on record as well as the provision of my lord, but here the point is also time consideration. The substantial question of law, which has not been taken into consideration by both the federal courts, that when there is no partition by means and bounds, under such circumstance, it cannot be, one portion cannot be surrendered. Only one portion. Unless and until there is partition by means and bounds. The joint space exists. Mercantil the argument advanced in part by the Islamic Council to the defendants positive said according to CS record of right exhibit 1, CS Khata number 51 is to recorded in the name of Babu Ram Bhagwan Bipin Bhagwan, son of Value Bhagwan. The original is Babu Ram Bhagwan and Bipin Bhagwan. They are sons of Value Bhagwan. Nayan Bhagwan, Dayan Bhagwan are the sons of Laki Bhagwan, Bipin Bhagwan, died useless and shared admitted into default upon brother Baburam Babu. As per case of the plaintiff and the plaintiffs have not produced any document related to the case number. This is that on the other side. The defendant respondent have put forward the case that is the fourth father of the plaintiffs has surrendered their share to the accident or to the registered deed of surrender, exhibit C and C1. Since the plaintiff appellant have denied this fact, they were duty bound to prove the same. Hindu minority and guardianship as came into effect on 25 1956 since the execution of the surrender case. Dayal Bauri and son of Nayan Bauri have surrendered 1.49 acres of the suit property. Then the suit property, then rest of the property share is still in existence. So nothing remained in possession of the plaintiff. Therefore, the Islamic Council of the defendant respondents have discussed the detail in materials without citation. Urged the court to uphold the judgment continued passed to the court.
You are the descendants of Nayan Boundary.
Nayan.
You are the descendants of Nayan Boundary. Nayan Boundary, right?
Supal Bauri, Shyamla Devi,
No, Nayan Boundary died issueless.
Son of Kanhai Bauri. They are sons of Kanhai Bauri. And Kanhai Bauri is the son of, only son of Dayar Bauri. Dayar Bauri, Nayan Bauri died issueless. Latu Bauri had two sons, Nayan Bauri and Dayar Bauri. So Nayan Bauri died issueless. Dayar Bauri had two sons. One son, Kanhai Bauri. Kanhai Bauri has Supal Bauri, his son, Supal Bauri, Samla Devi and Savitri Devi.
This deed of settlement was under challenge.
The deed of settlement, it was not under challenge.
Not under challenge.
Because it was not available. Original was not available on the court.
Second appeal number 383 of 2019. This appeal has been filed against the judgment dated 19/8/2019 within bracket decree signed on 29/8/2019 bracket close passed by the District Judge Roman 14 Dhanbad in civil appeal number 20 of 2017, whereby the learned First Appellate Court has dismissed the appeal and confirmed the judgment and decree dated 8/2/2017/16/2017 passed by the civil judge within bracket senior division bracket close Roman 6 Dhanbad entitled suit number 12 of 2002. The learned counsel for the appellant has submitted that the plaintiffs have lost in both the courts and accordingly they are the appellants before this court. The learned counsel, while assailing the impugned judgments, has submitted that there cannot be surrender of 2/3 portion of undivided share, and since there was no previous partition, the surrender of property by two registered surrender deed was not as per law, and consequently the plaintiffs were entitled for half share of the entire property described in Schedule B. The learned counsel has referred to the paragraph 7 of the appellate court's judgment and has submitted that this aspect of the matter has not been properly considered. After hearing he has referred to substantial question of law number 5 and 6, which are as follows. फाइव एंड सिक्स में तो कुछ पार्टीशन का बात ही नहीं है.
इसमें plaintiffs have not surrendered.
आप तो ग्राउंड्स दिखा रहे हैं.
Grounds.
वैसा कोई सब्सटेंशियल क्वेश्चन ऑफ लॉ बनाए हैं? नहीं बनाए. छोड़ दीजिए, इतना ही काफी है. ये रोमन 7. रोमन 7, राइट? राइट? खाली रोमन 7 है. इंटरनल पेज 10 ऑफ मेमो. After hearing the learned counsel for the appellant, court finds that the specific case of the plaintiff was appellate court Selenge, para number 2. Specific case of the plaintiffs was that 4.47 acres of land under 16 plots of Khata number 51 was recorded in the name of Baburam Bauri and Bipin Bauri, both sons of late Beto Bauri, 1 share each, and Nayan Bauri and Dayal Bauri, both sons of late Latu Bauri, 1 share each during cadastral survey operation. Beto Bauri and Latu Bauri separated themselves soon after cadastral survey operation and partitioned their land half and half. Bipin Bauri died issueless and his property devolved upon his brother Baburam Bauri, who died leaving behind his 4 daughters, but he transferred all his property to daughter Ramya Bauri. The plaintiffs have no interest in the property left by Baburam Bauri. Nayan Bauri died issueless. Dayal Bauri died leaving behind his only son, Kanhai Bauri. Kanhai Bauri died leaving behind Sufal Bauri and daughters Shyamla Devi and Savitri Devi. It was their further case that after death of Nayan Bauri, his property devolved upon Dayal Bauri and his brother. After Dayal Bauri, Kanhai Bauri succeeded the property, and after Kanhai Bauri, the plaintiffs have succeeded the property and they are in possession of the property. The rent receipts were also issued in favor of the plaintiffs and their ancestors. However, the plaintiffs had to file MP case number 13, MP case in the year 1992 under section 144 CRPC, when the opposite party, when the defendant tried to disturb their possession over the suit property. And at that point of time, it revealed that the defendants are claiming that the recorded tenant had surrendered the land to the ex-landlord through registered surrender deed in the year 1941 and 1946. And later on, the ex-landlord settled the land in favor of Buddhu Mandal. The proceeding was dropped. The case of the plaintiff was that the defendants have no right, title and interest in possession over the suit property. Dropped in 1992. Dropped by order dated 5/11/1992. In the meantime, in the year 2000, in the month of 2nd week of January 2002, the defendant had constructed wall in portion of the suit land. And when the defendant the plaintiff had objected, but the defendant asserted that the land belongs to them. And ultimately, but the title suit was filed in the year 2002. On the other hand, the case of the defendant was that Nayan Bauri died leaving behind his 3 sons, Buddhu Bauri, Lakhiram Bauri and Manu Bauri, who inherited 1/3 share of their father. They jointly surrendered their share under property of Khata number 51 to the ex-landlord on 6/4/1945 by registered deed of surrender and relinquished their right, title and interest over the same. The ex-landlord came in possession and Then Buddhu body had taken settlement of the land surrendered by late Nain Baudi. Dayal Baudi, the predecessor in interest of the plaintiffs, had surrendered one-third share in Khata number 51 on 29/4/1941 through registered surrender deed. Buddhu Boundary, grandfather of the defendant, had taken the settlement from ex-landlord by Hukumnama in the year 1941 and 1945 respectively, and since then the defendant are in possession of the property. And they paid rent to the ex-landlord, and after vesting, they are paying rent to the state of Bihar. It was asserted that the plaintiffs have no right, title, and interest and possession over the suit property. The plaintiff never came in possession. During the revision survey operation, the suit property was recorded in the name of the defendants. Out of 4.47 acres of land, one-third interest belonged to Babu Ram Baudi, which is in possession of his daughter and other legal heirs. The remaining two-third interest of the suit property, that is 2.98 acres under Khata number 51, is in possession of the defendants. The learned trial court framed the following issues for consideration. And both the parties led oral and document evidences. The learned trial court first took up issue number 5 and the court recorded that the court recorded the following findings against the plaintiff and decided the issue. Page number 19 of Trial Court Judgment. Q1 minute. The court decided issue number 6. And held as follows: para 5, issue number 4 is in para 6, issue number 7 is in para 8, and ultimately so far as issue number 2 and 3 are concerned, the parties, no specific finding was recorded and the suit was dismissed. So far as the first appellate court is concerned, the appellate court framed the 2 points for determination. एक ही point है ना? Yes, the only 1 point for determination, which is as follows. The learned appellate court recorded the finding in from paragraph 10 onwards. The so far as the learned court recorded a finding that the cadastral survey record of right with relation to Khata number 51 was recorded in the name of Baburam Bauri and Bipin Bauri, son of Redu Bauri, and Dayal Bauri and Nain Bauri, son of Lakhu Bauri, equal shares. There was nothing on record to show that a partition took place between the recorded tenant. However, the plots were shown in possession of different recorded tenants. This was recorded by considering the oral evidences of the plaintiff. The learned court recorded that discussed the receipts which were produced on behalf of the defendants, and also the Exhibit C, which was the copy of the registered surrender deed number 3464 executed by Dayal Bauri in favor of ex-landlord for dues of compensation. He had also surrendered 1.49 acres of 16 plots out of 4.47 acres under Khata number 51, and he had received the compensation. Exhibit CY1 was the surrender deed dated 6/4/1945 executed by Buddu Bauri, Lakhu Bauri, sons of Nain Bauri through guardianship of Radhi Bauri, wife of late Nain Bauri, surrendering 1.49 acres of land out of 4.47 acres of 16 plots after payment of compensation. For compensation of ₹59 paid by Buddu Mandal. It has come on record that after the aforesaid surrender, the surrendered land was settled with Buddu Mandal, who came in possession of the same, and after his death, his sons Moti Mandal, Kalipado Mandal and Jyoti Chand Mandal succeeded the land, and the divisional survey record of right was prepared in their favor. There was nothing on record to show that the minor sons of Nain Bauri ever challenged the execution of the registered surrender deed in their name by their guardian. Admittedly, the deed of surrender of the year 1941 and 1945 was not under challenge and it was never challenged. The court recorded that after execution of the surrender deed by their forefathers, the plaintiffs have no claim over the same, and the settled land was in possession of the defendant as per the materials on record, which was settled by Sada Hukumnama followed by continuous rate receipts. The learned court ultimately recorded that the plaintiffs do not have any right, title, interest with respect to the land which was surrendered by way of deed of surrender of the year 1941 and 1945 and settled in favor of the dependents. Admittedly, the deed of surrender under Exhibit C was 1.45 acres of land of 16 plots out of 4.47 acres of land in Khata number 51, and by Exhibit C by 1, the deed of surrender was for 1.49 acres of land out of 4.47 acres of the 16 plots of Khata number 51. In such circumstances, this court is of the view that the learned courts have not committed any error of law or on fact by refusing to decree half share of the entire suit land as claimed by the plaintiffs. There is no merit in this petition, which is hereby dismissed.
Judgment is also there. Reference has been made to the judgment.
चलिए आप लोग
It is,
आर्गुमेंट सुनने के बाद जजमेंट नहीं देगी.
From the daily list under heading for admission, item 33, first appeal 101 of 2026.
किसका है? No defect. Admit. Issue notice to the sole respondent. No, issue notice to the respondents for which requisite and the speakers be filed within a period of 2 weeks from today. Preemption. Let the records be called for from the concerned court. Since the counsel for the appellant is absent, a soft copy of this order be communicated to the counsel for compliance.
Date.
8th April.
Under heading for hearing under order 41/11 of CPC item 34. Second appeal 50 of 2018.
So you can say I number 02030. This is the substitution petition.
Of
Document number 1 and 8 I have that also.
when did he die?
Document number 1 that 69 2020 and document number 8 died on 23/11/2023.
16/9/2020.
2020 and document number 8 died 23/11/2023. Now, the second appeal was dismissed for default on account of non-compliance order passed this honorable court lordship. Thereafter, lordship, the petitioner filed CMP and due to the pendency of the CMP lordship, the appellant number 1 and 8 died lordship. And the appellant to file an application for substituting the names of legal heirs of appellant number 1 and 8, which was allowed and CMP was also restored. Thereafter, lordship, this application is made.
Second appeal number 50 of 2018. The learned counsel for the appellant has IE number 2203 of 26 has been filed for substitution of appellant number 1
And 8.
who expired on 16/9/2020 and appellant number 8 who expired on 23/11/2023. The learned counsel submits that the names of legal heirs have been mentioned in paragraph 3 and 4 of the interlocutory application. He further submits that the case the second appeal was dismissed on account of dismissed for default and was restored by CMP number 796 of 2020, and at the time of restoration, the appellant number 1 and appellant number 8 who were party in the CMP were also the appellant number 1 herein, appellant number 1 and appellant number 8 herein were also substituted in the CMP. He submits that the wakalatnama on behalf of the legal heirs have been placed on record along with the IE. Considering the submissions, IE number 2203 of 2026. Seeking the substitution of appellant number 1 and 8 and a prayer for setting aside abatement and condemnation of delay in filing the substitution petition through the same interlocutory application as
And you permitted to make necessary
counsel
correction
for
in
the
court.
appellant is directed to carry out necessary corrections in ready during the proceeding. अब मेरिट पे बहस करें।
Soma.
नहीं
Soma.
आप कौन?
I filed wakalatnama on behalf of respondent 1, 2, 7, 8, 9, 11 and 2.
यहाँ से कोई डायरेक्शन
Last date.
Substitution to restoration.
Yes, I am not
objecting. Counsel for the respondent has no objection so far as the prayer for substitution is concerned. बहस करिए बहस करिए।
Day after. इसमें कुछ जजमेंट मिला है, बहुत इम्पोर्टेंस में है। इसमें
सूट में जो प्रॉपर्टी नहीं था वो बाद में कैसे
तो रिलीफ ही क्लेम किए हैं ना,
क्या
रिलीफ ही क्लेम नहीं किए हैं ना। It is absolutely beg your relief lordship. I will show the judgment day after tomorrow lordship may be taken up. I will show the judgment lordship.
ये सूट प्रॉपर्टी था आपके क्लेम में।
That is another thing. But the relief should be specific according to order 7 rule 7.
What was this relief?
Relief not relief.
For declaration of right title.
हम really बता रहे हैं। The judgment and decree passed in partition suit lordship. I am reading that. The judgment and decree setting aside the decree of title partition suit number 20 of 1993 of the Court of Subordinate Judge. One, they were declaring the same as null and void, not binding upon to the extent of the suit land lordship. There are two kinds
The
of
extent of the suit land.
Yes, there are two kinds of decree. First, a preliminary decree, a second, a final decree. And there is a judgment of the Honorable Supreme Court that he is the aggrieved person of the judgment and decree passed by the subordinate
No,
judge.
that is not the same. You see, the judgment and decree which was passed by the court did not involve this property.
No, he could have filed the appeal before the.
Why should he file the appeal?
Because he is the aggrieved
judgment,
person.
just a moment, he is not a aggrieved person. A property, a person might have 10 properties.
Yes.
If only 5 properties are included or 7 properties are included in the partition suit and a decree is passed.
Yes.
Can a decree be passed subsequently at the stage of final decree with respect to remaining 3 also?
Lord, see, he filed an application under 1 Rule 10
Might have filed.
Before which was rejected. Against which was no revision was filed.
Order 1 Rule 10, no?
Yes.
He was not made party. It's okay. He filed his own suit.
Rejected.
He filed his own suit.
No, he can also file the appeal. There is a judgment of the Honorable Supreme Court.
Why should
Every person can
Why should he become a party to a suit in which his property is not included?
Then day after tomorrow, Lord, I will properly assist with judgment, Lord. So far, Order 7, Rule 7,
That is the crux of the matter.
Yes, I will show.
I was neither the party in the earlier suit and my property,
Your property
has been partitioned by them subsequently.
And your property was not even included in the
Included
partition.
in the plan.
But I will with respect to Order 7, Rule 7, and every aggrieved person has a right to preferred appeal.
No.
There I will bring the
Who is the aggrieved person?
He is the aggrieved
No,
judgment.
I am not agreed by that order.
Sir, you see, partition of a property which was not there in the schedule of the property, in the partition suit, that's absolutely, it just can't be done.
And subsequently entered, and I was not a party to that suit also.
Therefore, you are the aggrieved person.
No, not the aggrieved person.
Filed the appeal before the
Not the aggrieved person. No, not the
Then
aggrieved
okay, I will
person.
bring that.
This property is not there in the suit.
Then okay, I will
Then
bring
how
the
this
judgment.
property could have
I
been
will bring
partitioned?
the Order 7, Rule 7 and the aggrieved person. Okay? I will allow only 2 minutes any day lordship. Thereafter lordship may pass by. There is a direct judgment lordship.
Direct.
तो सूट प्रॉपर्टी नहीं होगा उसका भी पार्टीशन हो
Partition कर
जाएगा
दीजिए।
ऐसा डायरेक्ट जजमेंट है आपके पास
हम दिखाएंगे ना। हम
कल
दिखाएंगे।
हमको दे दीजिएगा थोड़ा हम भी पढ़
आपको
के
भी
आएंगे
दे
कौन सा
दीजिए।
डायरेक्ट जजमेंट रिसर्च करना
हम रिसर्च करना।
करिए रिसर्च सेकेंड अपील नंबर 50 ऑफ 2018 इसके आगे लिखिए Council for the Appellant has prayed that the matter be posted day after tomorrow.
Yes.
चलिए day after tomorrow supplementary causes पढ़ेंगे। कुछ भी बहस करिए। लेके आइए कि जो प्रॉपर्टी शेड्यूल में भी नहीं है उस प्रॉपर्टी का
है ना दो डिग्री है एक प्रीलिमिनरी डिग्री एक फाइनल डिग्री उनको स्पेसिफिक होना चाहिए
प्रीलिमिनरी डिग्री एक सेकंड लेट अस अंडरस्टैंड दिस परसों तक बहस करेंगे।
हां
प्रीलिमिनरी डिग्री में क्या होता है? प्रीलिमिनरी डिग्री में एक सेकंड थोड़ा हमको समझने दीजिए कि हम ठीक से समझेंगे। प्रीलिमिनरी डिग्री में डिसाइड होता है कि भाई आधा आधा मिलेगा 1/3 मिलेगा कितना परसेंटेज मिलेगा
यस
कितना प्रोपोर्शन यस फाइनल डिग्री में डिसाइड होता है कौन सा किसको मिलेगा
कौन सा प्लॉट अलॉट
ठीक है तख्ताबंदी के साथ ठीक है वैल्यूएशन वगैरह देखते हुए सारा चीज पोजीशन लोकेशन सेल क्या क्या हो गया वो सारा देखते हुए एलोकेट जो प्रॉपर्टी शेड्यूल ऑफ प्रॉपर्टी में है ही नहीं प्लेट क्या उस प्रॉपर्टी का भी पार्टीशन फाइनल डिग्री में हो सकता है?
दैट अब 41 31 का एब्सोल्युटली वायलेशन है नो पॉइंट
आज हमको बस इतना सा
हम करेंगे
41 31 नहीं सुनेंगे आपका एसी पर आप जजमेंट दीजिए
हाँ 41-31 कर दिया है।
नहीं,
कोई
41-30
कोई पॉइंट्स ही फॉर्मुलेट नहीं
कोई
किया है।
जरूरत नहीं है फॉर्मूलेट से, इसके लिए कुछ फॉर्मुलेट करने का जरूरत नहीं है. अ प्रॉपर्टी विच इज नॉट अ पार्ट ऑफ द शेड्यूल ऑफ द प्लेट, हाउ दैट प्रॉपर्टी कैन बी सब्जेक्ट मैटर ऑफ पार्टीशन इन द फाइनल डिग्री. बस आप इस पे जजमेंट
ठीक तो हम देख लेंगे, हम तो कंप्लीट देखेंगे
एकदम पॉइंट पर
स्पेसिफिक ही नहीं लाएंगे,
अदरवाइज आप मान जाइए.
Item 35, second appeal 19 of 2023.
Concurrent findings is there, Lord. I was the plaintiff. Suit was for leadership that two safeties to declare that both the safety is inoperative and void.
You were not seeking any specific performance.
My only short story is leadership that the my vendor and the defendant's predecessor in interest jointly purchased a plot having 20 decimals of the 90 divides. Then subsequently they partitioned that 10 and 10 each.
What was the name of the vendor?
My vendor, let's see,
You are the defendant?
I was the plaintiff.
You are the plaintiff. Concurrent finding?
Concurrent. Ramdev Pandey was my vendor, predecessor in interest. And Dileshwar Mandal leadership, he was jointly they purchased. Ramdev Pandey and Dileshwar Mandal jointly purchased the property.
Then 20 decimals.
20 decimals. And 10 and 10 both divided among themselves. Later on, Ramdev Pandey sold that his share, that is 10 decimal of land, to me.
By way of?
By way of registered assembly.
Registered sale. Dated?
Registered assembly dated 9/12/1980.
1980.
Yes.
Okay. Then?
Subsequently, Dileshwar Mandal was having two sons. He died leaving behind two sons, Jawaharlal Mandal and Nepal Chandra Mandal. And both brothers divided that 10 decimals, which was the share of his father. Yeah. In family arrangement, they 5 decimal each. Now, later on, the person Jawaharlal Mandal, who was just adjacent south towards me, he proposed me to sell 3.5 decimal lands by registration, for which agreement of sale was sale took place, and that took place in 19/7/2005 in favor of the plaintiff.
You are concerned that suit property is only 5 decimal.
3.5 decimal.
So this is 3.5 decimal.
That suit land is confined to that only. 3%.
So you want, so this property you are claiming by virtue of an agreement of sale.
Subsequent to that, that particular land was sold to me while
Sold to you only, the same land.
The same.
When was it sold to you?
Yeah, it was sold in
Registered sale?
yes, registered sale. 28/12/2005.
28
जी
12
हाँ 2005.
2012.
Yes.
Okay, it was sold.
जी.
Okay, then what happened?
Now the that vendor, that is Jawaharlal Mandal, he was having two tenants, that is defendant number 2 and 3. Their claim is, defendant number 2 and 3 are claiming that Jawaharlal Mandal sold 1 decimal of land and half decimal of land to them.
One to defendant number 2.
Yes, and half decimal to defendant number 3. And
Defendant
over,
number
yes,
3.
yes, by virtue of
Agreement or sale deed was also.
sale deed letter on sale deed was also
Defendant number 2 का agreement बताइए.
on the same date. It was both 2 and 3, 31st May 2005.
31/5/2005.
Yes. So
5 हो गया, पूरा 5 डिसमिल तो हो गया.
5 decimal.
हो गया. 19/7/2005 को आपको एग्रीमेंट हुआ और आपको बेच दिया 28/12/2012. Right? And you acquired 3.5 decimal of land.
3.5.
And the other two, defendant number 2 and 3, they acquired 1 and 1.5.
1.5.
And there was an agreement of sale.
Agreement of sale. Later on, they claim that they were also while the sale deed dated, 2 sale deeds were executed in favor of defendant number 2 and 3. 21st March 2006.
Different sale deed.
April 2006.
21/4.
जी.
So
now
it's a fact.
It is 1:30. I'll only take 2 minutes. 5 decimals of land is there. The bone of dispute is actually very short. 5 decimal land is there. The same vendor, defendant number 1, transfers the same property on to me 3.5 decimal in the year 2005, December 2005, and the same property.
No, December 2012.
12. And the same property he transfers it 2005.
2012.
My deed is earlier in point of time.
2005 लिखे.
वही
28/12/2005.
2005. हाँ. मेरा पहले admitted position is that my registered deed is earlier in point of time. Only difference is, and their deed is subsequent point of time, because their deeds are of the year of on 21/4/2006. So after 5 months their deed is there. Only problem in our case is it is their contention of the defendant number 2 and 3, because defendant number 1 transferred the property to 1.5 decimal, 1 decimal to one defendant and half decimal to another defendant. The only dispute is that the same property is transferred. This 1.5 decimal is within from my 3.5 decimal. So what would be the consequence of the transfers made to 2 different sets of persons with regard to the same property? Here specifically section 48 of Transfer of Property Act would come into play, because my deed is earlier in point of time and their deed is later in point of time. The trial court it says that because their agreement is earlier in point of time than us, therefore that would be revealed. That is one of the grounds. And it has come that their agreement is earlier in.
What was the occasion for you to file the suit?
File the suit.
Did you have any cause of action?
Yes, because it was the same property which had already been transferred to me in the year 2005, and the same property is now transferred in 2006 to the because I had already purchased 3.5.
You have put
So-
in possession.
Yes, but this particular area which is there, this included in our sale, but it was only mentioned Khapna Post house, yearly house. So possession with obviously with the persons who are in there. But it is not mentioned in it. Now their case is interestingly the dependent number 2 and 3 what they say that our agreement is prior in point of time, that means prior to our sale deed, because their agreement is prior in point of
So
time.
basically you are the bona fide purchasers of.
No, I say that I am bona fide purchaser, but what would happen, from which date the date under section 48 would be counted? It would be from the date when the date is the property is actually being transferred. Property transfer would take place only when the sale deed is registered. Sale deed in mine is registered in the month of December 2005, and their deed is registered in the year 2000, fourth month of 2006. So in terms of section 48, my deed has to prevail. One thing I must say against me also, let us assume this trial court, if it was a case of the defendant, that their deed was executed, their sale deed was executed prior in point of time, but it was registered at a later date, then the matter would have been different. But their own case is that only an agreement for sale was.
What is the finding whether you are a bona fide purchaser for value? Because you have purchased the property by at the stage when there is already an agreement of sale.
But whether this would be a ground, because specific, it was not a suit for specific performance.
That's right. But still,
And they did not file a suit for specific performance.
they did not file. There was no occasion to file. They did not file any suit for specific performance because there was no occasion to file. You, after having purchased also, you did not take any steps for taking possession.
This is the suit for which I am.
After 2005, when did you file the suit?
In 2007.
In 2007, you
Yes.
filed the suit.
Yes.
In the meantime, there was already a suit. There was already a sale deed.
Yes, same. It was the same deed was in the year 2000.
So, if there are two conflicting sale deeds, whether the sale deed, which is followed by an agreement of sale, then under such circumstances,
one very interesting stand they have taken, the defendant number 2 and 3. In their written defense, they have come up with this case, but they themselves in their written statement say that this particular fact that our agreement was already
did you
entered.
pay any consideration amount?
I paid entire
How much?
consideration.
When?
I paid, that has been mentioned.
When did you? Because there is a finding that you were not able to prove your consideration with respect to the agreement.
5,80,000 I have paid. I have paid more than the amount of consideration mentioned in this. This is the, and there is no cancellation prayer by any of the party. My deed has not yet been challenged by anyone. So therefore I was referring to section 48 of transfer of property. That if the same person executes two deeds with regard to the same property, then the deed which is earlier
We'll come back in the
in
second. We'll hear it in the second.
tomorrow.
आज ही
आज
अब इतना सुन लिया था
हम कोई है